bubble a little bit out. Other than that, he said, don't worry about the long waits.
Right, yeah.
We should be quicker.
Yeah.
Not sure. We need to keep talking. Good have some. So catwalk speakers, I've used this 100%. Somebody,
Yeah.
I've seen somewhere in Austin listening to this, but for sure.
Right.
That's fun. Thompson, hi, my name is Brian Casey. He just suddenly blows up.
Oh.
Oh, yeah. People are tweeting about Brian.
Oh, like,
What did he do?
Somehow-
Who is this?
Somehow hijacked it.
I know.
Meeting.
I think there's.
Yeah.
I think one of my,
I need you to-
my law club. I mean, that's something I had as fun. It was
Oh, it's.
that or
Not to have a conversation about trying to reach the,
Yeah.
figure out we stand here, keep talking.
Possibly at the beginning of the very observation.
Yeah.
The information we got was not working.
Right.
That's it. That's what
It's not working properly. They are getting some kind of signal. Which, yeah, I don't blame Preston for the commissioner part. That's different than knowing exactly what levels are. And it sounds like now that I have more information about Preston, maybe not 100% care. No, it works. It's all good.
No. And. That's my best.
Hello, everyone. Thank you for rolling with us with the audio difficulties. We're doing some testing right now. So I apologize for interruptions, but if we could have like a moment of silence for just a minute while they test some things, so that way they know what the zero level is, and then they can go from there. So just pretend we're at a moment of silence, and I appreciate it very much. Thank you for your patience. Test 1, 2, test.
Test, 1, 2. Check.
Check. Test 1, 2. Check. Good volume.
Test 1, 2, test. Okay. Thank you very much, everyone. Moment of silence is.
Okay, back on the record.
That was more fun.
That's the hardest thing we've ever had to do. So now. we supposed to use these mics or not? Yeah, well, let's see if, Dave, who is that up there? Judge Peoples, do you hear me? Thumbs up. All right, so we'll start there. And, see where we lined up. Where were we?
Passing the JP roll unanimously.
Did that ever happen before? I think we were, at the point where, Lisa and Kenneth were saying, let's not go backwards. But there was consensus that we haven't actually formally voted on this presumption argument, even though it has surely been discussed before. Would you agree that's where we are?
Yes.
Okay. So without going backwards, do we want to have a discussion, further discussion about the presumption of in-person, subject to trying to do it by alternate, or not? We get any thoughts on it? Yeah, Jim.
So I recall a conversation about a percent. It would strike me that the idea of presumption and as our now the idea of the court may work for the court may order and the party may request if it was and the party may request in person. That's correct. And then you get to the vote on both of those tracks, which the party's motion.
Well, that sounds obvious.
Well, it used to say must, and
Yeah.
that was a recommendation from the Access to Justice Commission, to change it to should. When you look at the factors, some go in favor of in-person, some go in favor of remote. And so we started to get kind of confused as we were looking at the factors. Because usually if you have a presumption, then you're gonna have these factors that then move you away from the presumption, right? Whereas these factors are more, they could go either way. Some favor in person, some favor remote. And so that made at least the ad hoc group looking at it from the access to justice perspective made us think we kind of lightened up that to should, so that it accounts for these factors being moving in both directions.
And I'll add that in that working group, as a reminder, Judge Chu was a member, and he had taken the prior version of this draft to a judicial conference and discussed it with colleagues and had received feedback that there was a desire for some additional discretion. It doesn't go so far as to say may, of course, but it has been changed from must to should.
They both do.
They both do. It's in 510 too.
Right. I'm just before it did not happen.
Now they go to.
No, they both do.
I don't. Um, somebody- part of the company.
Well, it's not, as noted earlier, the statutes and constitutional provisions address where the judge must be physically when presiding. And so it could be that there would be a comment about that, but to try to repeat what's in the statutes and the rules has been fleshed out by the courts didn't seem like a good use of space here, because it's already addressed in other places, and it could change, of course, if the legislature decides to change that. So in your
Couple of things before the record. Apparently, we now have to go to Mike. And not just mics, but they have to be right up by your face. So if you have a communicable disease, be careful. My hand is take fun. Nobody's getting sick up at this end. Because these guys are right on using, nor is she, just me. But anyway, that's so now Judge Miskel's got a mic. Fire. Well, back to your point about the presumption. if you put a presumption, think about Judge Ferguson's letter, and how would that presumption, if everybody read that, it's very compelling. He presides over remote area, vast geographic portion, state, multiple counties. So if you have a presumption, what does Judge Ferguson have to do with that? Recognizing he didn't want to travel, he didn't want to have people travel, and all the people being able to get there is very hard. So how does the presumption, does he say, okay, and anybody, even though there's presumption, he can prove anybody who must vote, just let me. Is that how it works?
This goes back to the conversation at first. I think that's the part, because you're going to have assumption. I think what very, and that's why personally I don't make sense of the presumption process. I think in some type of better. So if the concern is contested evidentiary hearings specifically, maybe the way to address that with this presumption is instead akin to something the jury trial. So obviously that's correct by the subject of the task.
So you got a urban and budget that's been my docket. I'm doing a motion docket Friday, and everything's going to be remote. And since I haven't read the Constitution or the statute lately, I'm going to do it from Walmart because that's where I can be that day. Pick up. How does that work? Go ahead, John.
But if we okay, ask them. I think that's good. Party, yeah. Oh, but work has to be there for other options.
Judge Miskel disagree.
So for example, our juvenile judge was using physical courtroom. Juvenile proceeding. Civil docket. And so if you were going to participate in person in the civil docket, it wouldn't be by automatic going to the courtroom because they closed juvenile trial or whatever. Does that make sense?
That makes sense. About this. Like to. That's
Right. You'd have to contact the court to make arrangements for it. And you were saying, oh, we can just assume that I go to the normal court range. Like, notice have to say, participate. And from the specific to JP, from the JP that were, they have a lot of obligations that are being posting some of their when they're out to declare some doing other things at the jail. So from the JP Court's perspective, they are doing for reasons that are necessary to complete their obligation outside of the court regulation.
Alistair Dawson.
So I can't hear much of what's being said. I find it ironic that we're having this discussion about remote hearings while we're having all these problems. But I think everyone should recognize that we have a significant access to justice problem in Texas. And it's only getting worse. And the statistics and the data prove that having remote hearings improves access to justice. And I thought that this committee had a pretty strong consensus in favor of allowing remote proceedings where necessary and where appropriate. And with all due respect to my friend Robert, having a presumption in favor of in-person is a massive step in the wrong direction. And so I think we should move forward with allowing remote hearings and remote proceedings where appropriate, not remote jury trials. That's a different issue, but remote hearings. And I also think, frankly, we need to start crafting these rules, because I think courts all over the state want to hear what the rules are for allowing remote hearings and remote proceedings in the future. So I would suggest we move forward with looking at the rules. If you want to have a vote, Skip, on thumbs up or thumbs down on remote jury trials, or maybe Robert suggesting either one, fine, but let's get to the rulemaking part.
Can you hear me?
Off and on.
How about right now? Okay, this is Skip weighing in on this. Yeah, Judge, like that. that's how I say it. Pretty sure you don't want to hear me saying that, Judge. Okay, I agree. Yeah, Robert. I think you are being Judge Esteves.
Broadcast Friday because so can I. So I don't know if the courts I the public does not have the right to correct. Public has the right to correct. So the fact that you're watching doesn't make a
All right, Judge Evans, and then Richard Munzinger, and then John Morgan.
Richard, could I have that microphone? One thing, Robert said.
I did not intend the public to be able to do anything, just. This point.
Richard Munzinger.
I agree with Alistair. We can't hear anything, and I agree with Alistair, but to me, the basic point is to maintain the integrity of the system. If you're searching for truth, you have to adjust these electronic rules to allow for what people do to fudge. And that's what concerns me. I'm not talking about jury trials. I'm talking about hearings at which the court might take sworn testimony. Anytime that there is sworn testimony, people are supposed to be telling the truth under oath, so help them God. We don't use God anymore, so help them. But the basic problem is to maintain the integrity of the system. Efficiency is not the point, in my opinion. In my opinion, the point is to maintain the integrity of the system. We are supposed to have courts to produce justice, and we can't miss that. We have to have these electronic rules to preserve that. I'm going to leave the meeting because I can't hear anything. Thank you, sir. Take care.
You bet. Thank you, Richard. John Warren, and then followed by Judge Peoples.
Thank you. Sir, I'm ready for and everyone that excellent students, high school students, enough to the party and starbucks access. Those we have to be able to rise of people who are representing who are how they when they go to court to represent. There's a distinction between by all means, like, but still, I lose.
Thank you, Judge Peoples, and then Judge Meskel.
Chip, I want to be sure that you and the people in the room know what is happening out here in Zoom land. About 25 of us by my count. When Richard Munzinger spoke just a minute ago, I heard every single thing he said loud and clear. When John Warren spoke just a minute ago, I think that I heard an occasional syllable. Okay, now, sometimes those of you in the room, when you have a good microphone, the volume is good, but sometimes we hear half the words, maybe 1/3 of the words are syllables. That's with the people where we've got volume. I would say 2 out of 3 speakers in the room, and I'm serious about this, sound like a mouse in a well. That's what they sound like. I mean, you can barely hear the little bitty noise. We can't have a meeting like this. I mean, honestly, I have not heard one idea from anybody in the room since we came back from lunch. I mean, I couldn't tell you one single thought that was expressed by anybody in the room. Now, the speakers on Zoom, I think, are coming through loud and clear. And I don't know, since the lunch break, I haven't heard anybody had a good microphone that I heard everything they said. And that's what's happening out here now. That's me. I'm on an iPad and I've got good internet service. I don't know what the rest of the people out in Zoom land are getting, but that's it. And I'm just not prepared to participate substantively in this meeting if I can't know what points are being made.
Yeah, it'd be, can you hear what I'm saying now?
Right now, I hear you.
Yeah, well, I've got the microphone inside my mouth. But it's not fair to ask the people on Zoom to cast a vote when they can't hear what's going on. So we're going to have to go a different direction in terms of whether we vote on this or not, vote on things or not. I can tell you about plans that I have for our next meeting, and I think we have to wrap up this remote proceedings issue, all aspects of it, because we haven't even talked about cameras in the courtroom yet, and that's a big issue. Or subpoenas. Subpoenas is a big issue, and so our next meeting we're just going to, do it until we finish it. And we ought to plan on a day and a half. And if we have to run over noon on Saturday, we'll do that too. But Judge Peoples, I sympathize with what you're saying and what Richard Munzinger and everybody else is saying. And all I can do is tell you we're sorry. And the people here at the law school have been working really, really hard to try to fix it. But after lunch, it seems like it's worse than it was before lunch.
Can I say this? For me, I heard everything that you said about 95% loud and clear. Why not have the people in the room line up maybe in ones and twos when they want to speak and go to the microphone that you just used, and we could hear what they say. They would have to walk to the microphone, or the microphone would have to be taken to them. I don't know, but you were in a class by yourself in what you just said compared to everybody else who has spoken from the room so far this afternoon. And that's just what I've heard.
I'm asking the court reporter to mark the part where you said I'm in a class by myself, and you could stop it right there. We've got several mics here, and we've been trying to talk into them. David, can you hear me talk? This is written.
No, that was very bad.
Okay, so it looks like my mic is a good one. How about Judge Miskell? Try yours.
Okay, Judge Peoples, can you hear me?
So far.
How about that? How about the mic down there?
Judge Peoples, can you hear me? This is Kim.
That was blurry, choppy and spotty.
Well, another comment on one of our members. Very sad. Okay. So it looks like we got two mics that might work. Mine and Judge Miskell.
Whoever talked then, I couldn't hear. I heard about a tenth of a syllable.
I promised I was going to break out in something.
So the answer is no. No, that was not better. So ditch that mic.
Chip, let me, rather than have people raise their hands, can you just look at the people who are on camera right now on Zoom, and they can go thumbs up or thumbs down? I'm telling you what I hear and don't hear, and I'm assuming it's the same for them. I'm seeing some chat messages, but Lonnie just did a thumbs down. Are you not hearing me, Lonnie?
I can hear you. I can't hear anybody else. Same as you're saying, Dave.
Okay.
Lonnie, how about me? Can you? This is Chip. Lonnie, can you hear me?
It's the same issue. It's sometimes we hear you, but most of the time we can't hear most people. And yes, it's gotten worse after lunch. Yes.
I don't know how to fix this. Maybe we should take a vote.
You want to? Well, that's the alternative. We could close our remote participants, we can become an in-person proceeding. Exclude the people who can't be here in person.
John. Can't hear a thing. Zero.
He doesn't want you to hear. He doesn't even have a mic. He's proposing something. I'll repeat it if it has merit.
Chip. Hey, Chip. Can you hear me, Chip?
Yeah.
Why doesn't everybody who's sitting there live get on Zoom as well? And you'll have a mic right in front of you and we'll hear you. Because we can hear everyone else who is virtual quite well because they're sitting in front of a mic on their computer. So you can be there in person and talk like you are to everyone else. And at the same time, it'll come over Zoom to us audibly.
Will there be a feedback problem in the room?
Do you just have to turn off your, if they.
I don't know, Judge Peoples, but this is about us, not them.
Yeah. Well,
I think
the people in the room could mute their microphones when they're not talking. Yeah.
Right.
That's the suggestion, but
these are all great suggestions. We're going to try Jackie's suggestion, which is to have a mic stand and my mic, which we all know works, and have people who want to make comments go up to the mic stand. Is that okay? So we're going to try that for a while and see what happens.
I'll say this, I heard everything you said, Chip.
No, it's not my turn to speak, but the irony of this happening while we're discussing what we're discussing is really overwhelming. And I'll just leave it at that.
The fact is there are 25 people participating who might not have been there if it were not for the remote access. Yeah.
Robert, when they do hearings, everybody's on Zoom. And so they get the audio that way.
Judge Backup, with your phone.
There was a judge. Yeah. The microphone, why don't we use the podium there? There we go.
You want to test it?
Just one audio, but just one.
Was that?
They want to try having someone here
Oh, here?
to when they speak.
Yeah. So you use the camera facing the podium?
Oh. Do you want to do the camera facing the podium then, or do you want to put just the mic?
Now let me get on Zoom on this.
You just want to use the
Yeah.
mic on here, sir?
Yeah.
Okay.
Will that work?
If you want to test it out? Yeah. Where am I? So, yeah, so we can switch the camera. That's okay. I can,
Here we go. Hollywood, baby.
Both remote and live.
You're hybrid. You're hybrid.
I am a hybrid.
want to know if you're there or here.
I'm so nowhere right now.
Somebody can call you something else.
All right, can everybody on Zoom hear me?
Yes.
Okay, so so Kent, you got your hand up. What do you want to say?
Other than agreeing with the comments about the irony of all of this, I just wanted to start by saying I agree with Alistair's comments that aspirationally, we've got to expand the use of remote proceedings for a host of different reasons. At the same time, you know, there's a but here. And this makes it, you know, painfully clear, I think, the episode this afternoon, that the scope and type of the proceeding you can have consistent with fairness, due process, the like, is in no small part dependent on the quality of the technology that's being used and the standardization of that technology. I have had the luxury of being in locations in which one conference room was connected by, you know, a Zoom conference with another conference room, meaning multiple participants in each room. And the technology was extraordinarily good, with cameras that would zoom in on who was talking, and with the room wired in such a way with microphones located that you could hear everything. In fact, I will say that I was warned, don't go in the corner and try and whisper to someone. You need to go outside the room, because that's the way the rooms were wired. But it was extraordinarily expensive. I mean, I made some inquiries because I was so impressed. The point I'm making is that when we think about this and incorporating this concept into the legal system, it seems to me we've got to think about standardizing minimum best practices. And I think we can control for two variables, although it would take some time and certainly take money. And that is for the courts and the lawyers. And I think you're going to have to start small with, you know, things like fairly routine hearings, non-evidentiary hearings and the like. It's just going to be tougher with everything uneven. I don't know how you control for the variable of parties that may be pro se and the like. And the dilemma there is, and I think Alistair may have been implying this, is that those are some of the proceedings in which they're needed most. Although at a minimum, we could probably very clearly indicate to pro se litigants or other independent parties that had some role to play what the minimum technology requirements were to participate in a hearing and do it in a way that was going to be efficacious. In any event, those are just some thoughts. And that is, I think that without returning to the really important practical baseline of the technology components of what we're talking about, I think we run the risk of missing the mark. Enough said.
Okay, thanks, Ken. So to try to tie this off, let's take a vote on whether or not 500.10 paren B paren should be amended to have some language at the beginning that says the presumption is that proceedings will be in person, however, comma. Everybody in favor of that, raise your hand. Shiva, you're going to have to give me a count for, all right. Everybody opposed to that, raise your hand. Shiva? So there were 10 in favor, 16 against, so we won't include that language. Is there any other matter on 500.10 that we need to talk about?
The comments might be worthy of discussion because it has been modified extensively since the
Okay.
last meeting.
To everybody take a look at the comments.
It defines good cause
Which defines good cause, right?
in a non-inclusive philosophical way.
A non-exclusive. Go ahead, you've got the camera.
Oh.
Well, I will show it.
Ken, what page do
So
we need to?
just to orient people and,
What page? They want to know.
hey, Lisa, do you have the page?
The red line is 433.
And then 310, is that where?
Is that yours?
Yeah. So if you want to see a clean version, it's on page 310, I believe.
Yeah.
So you can go there to see it in clean version, and then the red line is
433.
433.
You want to tell everybody what you all did?
Yes, I'll go over this again. So essentially, what's happened here is an expansion of the factors that can be considered when assessing good cause. It's still non-exhaustive, it's just examples. And so the phrasing of the factors that were there before has been modified to a degree, and then additional factors have been added. All of the additional factors that have been added in the modified phrasing comes from the Texas Access to Justice Commission Rules Committee, but it was adopted by the task force subcommittee in full.
Great. All right, anybody have any comments either online or in the room? And if you have a comment in the room, come join me at the in the television studio. Jim Purdue is making his way to the podium.
This is gonna eliminate comment
This is my effort to frustrate Ms. Hobbs' agenda and her obedience to the issue that's at hand. Since we're talking about the JP rule, and I've already told you that I'm more interested in the district court rule, and but it's an equal comment, so it applies to both because the rules are the same. And the thought is this, which is, would you be amenable to the idea of adding another enumerated thing in the comment of it, because you have the complexity and numerosity of witnesses? And it occurred to me that could you add contested evidence and credibility determinations as a potential factor that would assist the determination of whether good cause? And that was the hopefully productive, even if off agenda, comment.
Jim, we've talked about that millions of times. No, it strikes me that's a good add. Any other comments in the room, and then we'll go to the Zoomers. Yes.
I think that's a good addition. We have complexity of the case already, like you said, and the only question would be, and I don't think it matters where we put it, but do you have a preference in the list? Okay.
All right. Anybody else in the room have any comments? This having to walk to the camera is having a inhibiting factor influence on people who want to talk. Okay, we got somebody up. It's Judge Schaefer. Judge.
I think that's a really good addition. Most of the other items are kind of external to the intricacies of the case, but this is an internal factor that is equally as important as all of the external factors are.
Yeah, I think so too. Kent.
I'm just a big fan of certainty, and I get concerned about suggesting what is in effect a balancing test the court should consider, and then a long list. That's like a kaleidoscope is what my concern is. You turn it one way and turn it a different way. People see different things and the results are all different. even though sometimes the circumstances seem to be nearly identical, I think we'd be better off with hard and firm rules to the extent possible as to when you can use a remote proceeding and when you can't. I'd love to get it to the point where, virtually everything is subject to remote proceedings. I cite as Exhibit A this afternoon, we're not there yet.
Professor Hoffman.
Thanks, Chip. So I guess my comment is specifically about the whether it makes sense to include all the substance, separate from Kent's point that this may be too much. If we are going to include it, does it belong in the comment? And I guess I'm asking this not just as a stylistic matter, but I guess I am curious also for just our work going forward. Am I right in saying typically comments are not this sort of substantively laden typically? This feels like it's the comments doing a lot of substantive work in a way that is not as usual for the court. So anyway, I'd be interested to hear what people have to say about that.
Well, the comment sisters are talking to each other, and
Lisa Hobbs and I were just talking about the fact that over the last few years, I think it's become more common to have substantive comments to the statewide rules. And an example of that in the not too distant past is the expedited actions rule. And I believe that is actually what prompted this approach, because the expedited actions rule comment addresses non-exhaustive factors of good cause.
all right, Judge Peoples.
In the comment, item 2, complexity of the case, we probably mean the case and just as much the actual hearing that the judge is going to schedule. So, I mean, you could have a very complicated case, but a simple hearing. And so I think it ought to cover that. And then the prefatory clause there, when evaluating a request under subpart B, I think I would want the court to consider some of these factors into making the decision under number A or subpart A. Maybe not all of them. Those are just thoughts.
Hey, it's Lisa. Judge Ferguson and I talked quite extensively about that. Those are factors that they're what a judge is looking at when they're deciding if their default, their own personal judicial default, is going to be come to the courthouse or come to the hearing or come do it remotely. So I think you're right. Like, the thought process is in the judge's head when she decides how she's going to run her courtroom that week, that day, that afternoon. We can lay it out under this rule and drop off subpart B, but it's what's happening already in the initial decision.
Thank you. Alistair.
So, in response to Kent's comment about let's have hard and fast rules, I don't think that we can, because there are a variety of factors that affect the determination of whether to have remote hearings or not. And I think that they're well captured by this comment, in addition to what Jim suggested. And I don't know whether this makes a difference or not, but I wonder at the beginning, the second sentence where it says the court should consider, whether that might not be better if we change that to may consider. So it's the court can decide which of those factors to apply in making the determination. Those are my 2 comments.
Yep, the Kenan and Lisa think that's a good suggestion. They're off camera, but yeah, Harriet. You may have to come over here, Harriet.
Told Chip earlier, I'm very hesitant to take work that's been going on for years, get in the middle of it. But with respect to these comments from an access to justice standpoint, we wanted to say to the judges who may not have thought about it, these things are things that you need to think about when litigants are having to travel a great distance to the courthouse, or they have a family, an elderly parent, a child. We wanted to remind people, please think about these. So they are not dictating, but they are reminders. And while I'm here, so I don't have to come back up, I want to say, Judge Ferguson letter is in there for a real reason, and that is that he's living this, and he's way down the road in using remote hearings to create economy, to give access, and to accomplish justice. And so I really commend a close read of his letter.
Thanks, Harriet. Kent.
I just thought I'd briefly respond to Alistair and give sort of an example of what I'm talking about. First, as I said before, I think that we need to specify the minimum technology requirements for the courts, and certainly at least for the lawyers. Second, I would think that you could easily facilitate non-evidentiary hearings in a very bright line way. And I think we ought to encourage that. You're talking about essentially having the lawyers or pro se litigants and the court involved, all presumably on Zoom or similar technology. That's something that you could do in a very straightforward fashion. The trick is, in my view, the last category, which would be some kind of evidentiary hearing. And I think you ought to try and facilitate that, but I suspect it's going to have to be circumscribed. They're going to have to be limited, with limited aims, limited numbers of moving parts, and I think that you could consider how to specify what you can do and what you can't do. I think full-blown trials, jury trials, and the like, currently my view is that's beyond the pale. But in any event, that's my 2 cents.
Okay. Any other comments, either online or in the room, about 500.10 or the comment? Okay, so we've got that behind us. What about Rule 21 is the next one?
That's correct.
Why don't you come up and
The current version of proposed Rule 21 is on page 311 of the PDF, and it's redlined against existing rules. And I should have said more precisely, we have Rule 21 and Rule 21D. So the first part of what you see here on page 311 of the PDF is a red line of Rule 21, specifically to have amended notice requirements that track what we've already seen in the JP rules and already discussed in that context. And then everything in 21D would be new to the rules. In other words, this would be a brand new rule. And as has been noted several times today, the language here tracks what you've seen in 510, with the exception that it doesn't include in 21D the notice requirements, because that of course is covered in Rule 21.
you said 510, you meant 500.10.
I did, thank you.
Okay. Any comments about this? Come on, Richard, Robert, why don't you come on up here? It's lonely. Lonely up here. Watch out, guys. Robert's bringing his notebook.
Thank you, Chairman Chip. So we're discussing what we should put in notices to people who are participating in a court hearing, but we're really debating is whether we ought to be having remote proceedings or not. And I think that it's fine for us to debate that, because obviously we haven't all made up our mind yet. But it seems to me that on a going forward basis, it would help me, and I hope maybe help others, to keep just a few things in mind. And this doesn't address a particular solution, but to me, the first question is, where will the judge be? And the second question is, where will the court reporter be? And that may be in the same place or it may not. And it may be the court will be virtual or the court will be in the courtroom and present.
But I think that that's the first question that we have to address, and the presumptions and everything else applies to where will the judge be? Will the judge be in person in the courtroom, or will the judge be virtual? Secondly, we have options. The court could mandate that everything will be in person. So all the witnesses, all the lawyers, all the court personnel will be in person. Or the judge could make it elective that you can be in person or you can be by Zoom at your election. Or the third one is it's remote only and nobody will be physically present in the courtroom, which I guess is what I would say where the judge is going to be. And then the last point I would make is we're giving notice not just to the participants and the witnesses, but also to the public. So I think that we need to recognize that our comments about the information that we're sharing is not only going to the lawyers and the witnesses and the parties, but also to people in the public that may want to know how they can access the proceeding, which wouldn't be by Zoom, it would be by YouTube, I think. So I think if we can, in our discussions, if we can maybe hone in on the part we're talking about, it might lend some clarity. Chip, thank you.
You bet, Richard.
May it please the court. Just to note an issue that that Richard referenced, and I understand that you wanted to avoid the issue of where the trial judge should be, but I do think it would be helpful to include at least a comment with reference to applicable statutory or constitutional provisions, because the average litigant and potentially even a court wouldn't necessarily be fully aware of that. On this proposed rule, and it really, I think, pertains to the language of 21D, I've made my point on the issue generally, but I do think that we should draw a distinction similar to the distinction that's here on remote jury trials, that the same should apply to evidentiary proceedings where a witness will testify. So if the parties want the proceeding to be remote, that's fine. That will probably be used often. But if one of the parties wants the ability to question a witness in front of the court, that should be an option, and maybe a higher standard to rule otherwise, but it shouldn't be an even call. So I would suggest adding that language, basically under the language of 21DA, after for a jury trial or contested evidentiary proceeding where witnesses will testify. No questions.
All right, thanks. Any other comments in the room? Any other comments in line, Alistair?
So I agree with Robert on not having remote jury trials, but I disagree with his suggestion about basically allowing one party to mandate an in-person hearing if it's going to be an evidentiary hearing, because I do think that makes it more difficult for pro se litigants to appear. I think that it gives an advantage in sort of like debt collection cases to the party seeking to collect the debt. And you know, I trust our trial judges to determine where it's appropriate to allow for remote proceedings. And so mandating it in every contested evidentiary hearing, mandating it in person is an unnecessary impediment to access to justice, in my opinion.
Thank you. Judge Peoples.
A couple of remarks. By the way, I think that 21D and 500.10 are fine pieces of work. I think they're very, very good. I would make this point first. even though we have identical rules right now, basically for JP courts and for district and county courts, we need to keep in mind that those courts can be very, very different. The justice of the peace, I can't think of any time when the JP would be holding court outside his or her county. And many times that's true of the district judge. But Roy Ferguson, and by the way, his memo that Harriet Myers mentioned is exquisite. And if you haven't read it, you need to read that 4-page memo. It's incredible. But he has 5 big counties that make up 20,000 square miles. And I don't know where he lives, but he lives in one county. He doesn't live in the other 4. And to require him to be in those other courthouses would wreck his wonderful work out there. And so people like him, and maybe in Houston too, sometimes judges will need, it makes sense for them to not be in the courthouse, but certainly a multi-county judge should not be subject to that kind of rule. And so it would be wrong, I think, for 21D to put in kind of requirement like that the judge has to be in the courtroom for a trial. Now, the second thing, we just need to remember, I'm steadfast on not letting a judge make people try a jury case remotely unless everybody agrees. But I think non-jury merits hearing are different. For example, and I've done a bunch of family law. I've had trials on the merits in family law that took 5 minutes, 10. Very common in a family law case for the people who walk in, trial on the merits, child custody maybe. Judge, we've agreed on every single issue in this case except child support, or every single issue in this case except visitation. And the witnesses might be standing at the bench, and it might take a few minutes for both of them. So we can't say that every merits hearing, trial on the merits would have to be in person, unless they agree. I wouldn't want to give one litigant or one lawyer the right to veto whatever happens by saying, I insist on my right to an in-person hearing if the other person is willing to do it remotely. They may live several hours away. So there are lots of merits, non-jury trials on the merits that are very, very simple. And the people might be a long way off, and makes complete sense to let them be remote. I'm going to have some more to say about the privacy issues, and I know it's not an issue in the language of this proposal, but that's all I have to say right now. Thanks.
Thanks, Judge. Judge Schaefer.
Ultimately, someone has to have the final say. And I have found it's unusual that if you get the parties to agree, especially in a highly contested matter. Second, I wholeheartedly agree with Alistair that I think the judges should be the one making the call, taking into consideration as many of the factors as you want the courts to take into consideration. I think most people like the remote stuff that we've been doing. I know I do. It's still my default on hearings, but I have colleagues down here in Harris County who are completely and totally in person now. Some want it, some don't, but I think it should be an option that the courts have. And I think ultimately, whether you do it or not, should be the decision made by the courts. I know that sounds odd because I'm one of the courts, but I really feel like I'd be saying the same thing if I was one of the lawyers in the case too. It just makes sense that the judges make that decision. It also makes sense that the judges utilize everything they have at their disposal to make this call. And I've talked with Roy Ferguson before, and he is a perfect example of why it's a good idea to do remote proceedings. And there are times when it's not the right thing to do, but I think it should be something that we have access to. And I think this 21D rule is a real good rule, and I plan to vote for it if you give me a chance to vote for it.
Okay. Want to vote for it?
Aye.
All right. Professor Hoffman, you had your hand up, but then maybe it came down. I don't know. Nope. Okay. Anybody? Yeah. Tom Riney is making his way to the podium as we speak.
Thank you. I don't want to repeat any arguments that we've heard over the last several meetings, but I was sitting there thinking this afternoon and late this morning, if this were a hearing where I was representing a client in a temporary injunction, which almost always involved very serious rights, I'd have been moving for a mistrial. And I would hope that it would have been granted, but that's totally to the discretion of the judge under this rule. I second what Robert said. There should be a carve out, like for jury trials, for contested evidentiary proceedings without agreement of the parties. Agreement of the parties can always allow such a proceeding. I read almost all of the letters that were submitted, not everyone, but most of them. And I read Judge Ferguson's letter. It occurred to me that most of the arguments being put forth with those are with respect to certain types of cases. Certain types of non-evidentiary matters, certain types of CPS cases, family law matters, and so forth. I will admit that I'm a little territorial. I don't know much about those types of cases and can't speak to them. But I do know in the ordinary civil case or a civil case that doesn't involve those matters, there's almost uniform opposition from the lawyers involved. We talked about the letter that was submitted by 6 different trial lawyer organizations in Texas. I think we have to give some account to that as well in determining whether or not we want to give a trial judge total discretion to conduct contested evidentiary hearings using technology like we've seen today. Let me also suggest that outside of the major metropolitan areas, what courts have the expertise on technology and the staff available that we've seen here today? There were 5 technicians over here at one time. That's not the case in the average courthouse. So I think Kent Sullivan's comments about we need to have some minimum standard procedures before we launch off and make this very major change in the way we have proceedings absent agreement. I think everyone here agrees there are certain proceedings that are very efficiently conducted by Zoom, but we need to at least have a carve out at this period of time at this type of technology for contested evidentiary proceedings. Thank you.
Kent Sullivan.
I was just going to add, I agree with Tom's comments very much so. And I thought Judge Peoples had some great points, and I actually think you can sort of reconcile them. And that is, I think as a general rule, there ought to be a carve out for evidentiary hearings like is being suggested. And I think it's going to require very thoughtful consideration of the cases and situations. And Judge Peoples was illustrating some of those in his comments that would merit the use of remote hearings in perhaps evidentiary situations. And I think we just are going to have to go relatively slow about that. Over time, I think you're going to see a convergence between the increase in the technological capabilities of the litigants, lawyers, and the courts, and the scope of what we can handle remotely. But right now, I think it's really important that we go in a really thoughtful and methodical manner in terms of adding those sorts of proceedings to the list. And I don't think it should be just left up to the discretion of every individual judge. We've got an extraordinary number of judges in Texas. I think they're very different in terms of their outlook, their experience, their capabilities. I think that's a real problem. I don't think that model works. Thanks.
Thanks, Kent. Justice Christopher.
Well, yes, first of all, I'd like to say for those courts that don't have remote technology, this doesn't mandate it, right? And if the judge did an in-person hearing and somebody said, well, I want remote, and the court says, well, sorry, we just don't have good technology here for remote, then, that's good cause to deny his request to appear remotely. So I think the technology is kind of a red herring. And while I do understand the concept, and I know lawyers always think it's better if everybody agrees to everything. I echo what others have said about how that often doesn't happen. And let's examine that that temporary injunction hearing, right? And maybe your witnesses are out of town. And maybe you have one witness that the only thing that they're going to do is prove up receipt of something. Now, are we going to scuttle the entire procedure by mandating that that witness has to come in person because, I'm not agreeing to? That's the kind of call that, people need their advocacy skills for. That, I need to call this person remotely. Please let me do it in the context of this situation. So I think we've done an elegant solution. My subcommittees have worked really hard on it, and I hope you all like it. Thank you.
Alistair.
So I would just point out that in the factors that are set forth in the comment, the court can consider the complexity of the hearing, the complexity of the evidence that's going to be submitted. Those are factors that are included in the comment. And so the trial judge has the ability to, consider the complexity of the hearing and the complexity of evidence that's going to be submitted at the hearing and make a determination whether remote proceedings are appropriate or not. And so that's a better way of handling it on a case-by-case basis rather than having an entire carve-out for any contested evidentiary hearing, in my view.
Thanks, Alistair. Here comes Judge Miskell. Watch out.
I don't want to beat a dead horse. I know we've discussed this at length for 3 days now. What we've seen in the data reported by the National Center for State Courts, the Texas Access to Justice Commission, the anecdotes from judges, all of it says that for cases where individuals are the clients, there are substantial increases in access to courts. And the loudest opposition that we hear relates to civil cases on the jury docket. And so one thing I would shift away from our language today, we're treating this like this is some sort of hypothetical, theoretical, potential new thing that we can't predict. When in reality, each one of us has done thousands of these over the past 2.5 years. So for every person that's saying, well, I don't know how this can work, I mean, we have millions of hours of examples of it working over the past 2.5 years. So what I would say is, when we limit it to non-evidentiary, I wouldn't set a case on my docket for a non-evidentiary hearing. People don't need to be in court unless we're taking evidence. So all I do all day is evidentiary hearings. And I totally agree with the judge that says, I wrote down, quote, full-blown trial. A full-blown trial could be 10 minutes to admit a pay stub into evidence, ask the guy about overtime, and apply a formula that's in the family code. And that person may work out of state or whatever it is. So to be prohibited from allowing that person to do that pay stub calculation remotely, if the other side prefers to have a default, is unjust to me. I am passionate about this, not because I like technology for the sake of technology, but because I've seen the faces of all the same people that we've heard about from the Access to Justice Commission, and I want them to continue to be included. I believe our Texas courts are for all Texans, and I think this COVID crisis has really shown us all the people that we were excluded. So I think the rule is great the way it is. If the thorn in everyone's side is civil cases set on the jury docket, and you want remote appearances to be by agreement only in those cases, those aren't the injustices we're trying to prevent anyway. So if the rule is going to sink or swim on the opposition of people concerned about civil jury cases, then I would propose an exception for, if your case is a civil case set on the jury docket, then remote appearances can be by agreement only. As long as we can continue to do remote appearances for CPS cases, family cases, probate cases, self-represented litigants, all the people who don't do well in person. So I, number one, propose that we approve the rule as is. If the vote happens and that fails, I would propose an exception for civil cases set on the jury docket. Those can be by agreement only.
Okay. Hey, hang on for a second. What about the argument that Tom makes about injunctions. The petitioner, or the movement is trying to take away somebody's liberty. You know, their ability to move, or see their kids, or use their land, or, you know, what about that?
Yeah, so I mean, injunctions are what we do in family law most of all. I mean, we have temporary injunctions, you know, the majority of cases that we do. On my docket every day, I set 3 final trials, I set 3 temporary injunction hearings, and I set up to 3 family violence protective orders. So each and every day of my life, that's what I'm doing. And the alternative is to shut the door to those people that want to appear remotely. So it's like, what if, so you're trying to take someone's kids away. What if she's home with the toddlers and doesn't have a car, but says, I can participate in my hearing about my kids by Zoom? You're going to say, no, it has to be by agreement only. You think the abusive husband is going to say, sure, I agree to her participating remotely? Or do you think it's good news, I can close the doors of the courthouse to her? So I think the judges are in the best position to evaluate all those factors that we listed, evaluate game playing, evaluate the sophistication of the parties, evaluate the complexity of the hearing, the technology of the court. It's going to be different region to region, county to county. And I think the people on the front lines with the case are the ones who can best spot that type of inappropriate game playing that doesn't advance justice.
Okay. Thank you. Judge Mendoza, is that your hand is up.
Hi, good afternoon, everyone. The danger of following Judge Miskell. I want to say at every meeting, she says exactly what I want to say. I've written in my notes that a couple of people had said that we need to go slow. And I want to say, we have been doing this for over 2 years. We have been having evidentiary contested hearings for over 2 years. And I want to add, I don't do family, so I know that that's been busy, but those judges work really hard and they handle trials all the time, adjudicate credibility. They're making disputed decisions all the time. But I wanted to add that I'm even doing it in the criminal context. We have to have contested revocations. If nothing else is holding a defendant in custody, we have to have evidentiary hearings, and that's essentially a trial in a revocation. And the only way that's happened over the last 2 years has been by remote appearance, and that includes inmates from the jail. So we would not be going fast, we would be going backwards if we don't move forward with these rules, because we have been doing this. And I want to add that on those civil jury trials, if there needs to be a carve out, I will tell you that takes care of itself as well. In the last month, I have tried 2 med-mal cases. In each one, the parties wanted to have their experts appear remotely, and they were able to question and cross-examine. And it wasn't perfect, by the way. I almost zoomed off because it was so frustrating this morning, but this is so important. So I stayed on, and I want to share with y'all that we do have these problems. We do have technology problems, but it is a red herring because you figure it out and you move on. And in both trials, we had some, the last one was the expert at Berkeley, and he was having trouble with his Wi-Fi. So we had him, log off and log back in, but the lawyers had no problem, and it was their preference. Again, that's by agreement, but I actually think that the civil lawyers want remote appearances too. And in my last two med-mal trials, that's what they did. If given the opportunity, I would vote for this very elegant, very thoughtful rule. I think the committee has done a lot of work on it, and I would support it.
Thanks, Judge. Levi Benton.
Thanks, Chip. First, I intend to vote yes on this rule. I think it's a great rule. But I wish there were a tweak. And the tweak I'd like to see was language giving the court discretion to assess travel costs and inconvenience where, say, someone insists on having a witness appear in person when it's really calculated just to harass, and after everything's all over, it's clear such a witness didn't need to be there in person. Anyway, that's all I got to say. I'm voting yes, if you give us a chance to vote.
Okay, thanks, Levi. John.
Okay, everybody. Remote proceedings will not work unless we put them in place and define how we need to make them work. Build the parameters around them, but we have to have it in place. That's the only way we're going to figure it out. We don't want 3 years from now for anyone to say, did we not learn anything from the pandemic? Those 3 years that everybody's been talking about is about how do we make justice continue? How do we put remote proceedings in place so that we can continue it? That's the work that we have to do. We have to make the tough decisions, put remote proceedings in place, figure out how to work around those little things that we need to fix in order for it to be a perfect or close to perfect system. Thank you, sir.
Thanks, John. All right, any other comments in the room? I see no hands up online, so several people have been thirsting for a vote. I'm not sure what we're going to vote on if we do vote. There have been a couple suggestions that you all have thought were good ones.
I think that if I were the chair, the vote there seems to be this group of people who may want to carve out contested evidentiary hearing.
Okay.
And I bet we'll get a good sense.
That's a fair point. I don't know if you heard that online, but Lisa suggested that we frame a vote around the issue of whether or not there should be a carve out for contested evidentiary proceedings. And Kenan is going to make an amendment to that suggestion.
I just want to add that I think where things stand right now, with Jim Perdue's good suggestion, is that we would have a factor for good cause in the comments addressing contested evidence and credibility determinations. So this is a vote from my perspective that's taken with that comment being in place.
Yeah, that's what I was alluding to when I said there were suggestions that you all thought were appropriate. Yeah, Harvey.
Just procedurally, we're voting only on the evidentiary hearing, not jury trial issue for now. We might vote on one different than the other.
Yeah, that's.
Jury's off. I just want to make sure about that.
Yeah, we're not voting on jury trial. I think we
carved out there already.
I think we did carve that out. We did vote on it, and we did talk about it a lot. So now, this would be Judge.
I just want to clarify. I just want to make sure that what I would be voting for is whether or not the judge still gets any discretion. You're saying at that point the court has no discretion to make it remote.
Okay. Judge Esteves wants clarification on what we're voting on, and she suggests that the vote will include the concept that absent agreement by the parties, the judge does not have discretion to order a remote proceeding when it involves contested evidentiary matters. I
just wanted to clarify.
No, I know you want that clarified. That's the vote. That's what we're voting on. Is that what everybody agrees we're voting on?
Yeah.
Oh, huh? Yeah. Okay. So everybody that is in favor of a carve out in these rules, similar to the jury carve out for contested evidentiary matters, raise your hand. Everybody online. Shiva, how many did you get? Okay, everybody opposed. Online. All right, so opposed were 23, in favor 14, the chair not voting, so that carve out will be carved out. Yeah, Jim.
I heard a slightly different iteration of the concept by Judge Miskell. idea that if you're on a civil jury docket, that a contested evidentiary hearing our special accommodation for family lawyers, which is a historical fact of this community.
Jim Purdue is raising the point that Judge Miskell raised another point that is inconsistent with what we just voted on. Yeah, this is Tinker Tailor Soldier Spy stuff. So
My amendment was acceptable to the author. I'm in pretty good. I'm full of it.
all right, so there's just going to be no more discussion about that. So I think we've probably beaten this horse today as Judge Peoples. Apparently not. Yep. I voted in favor of the rule as is and against that motion, but I am sympathetic to the arguments in favor of I don't know. Let me say it this way. There are lots of venues in this state where that discretion will not be exercised correctly. And so I'm not so concerned about the family law cases, but what Tom Riney and others said about the injunctions in serious non-jury matters that are evidentiary, if we've just allowed judges to ram down their throats a remote hearing. And sometimes that'll be the right thing to do, but sometimes it won't. And I just think that before the court adopts this, hopefully they'll come up with some way to let judges know that there are lots of non-jury matters that are serious and that ought to be done in person. I don't know. If you give people the right to object, give judges the right to do this, it'll be abused. And I'm concerned about that, but I think the vote was correct. Just wanted to say that. No, that's helpful. Thank you, Mr. Mandamus.
And I'll just to that point, I think that a comment made earlier today is worth repeating now, and that is that when we're drafting the rules, I think we draft them with a qualified judiciary in mind. And with the understanding that some judges are not going to do what they should, but that's part of the reason why this rule has built into it a mechanism for mandamus when that's needed.
Great. Yeah, Judge Mendoza.
So I wanted to add that I am very proud of the El Paso judiciary, as just Heck mentioned, again, still not a backlog, but I want to say that even within a local, judiciary, you're aware that not all judges are the same and that not everyone has the same rules. So I just want to share and also put on the record that what we're doing locally is trying to make sure that we're taking care of the bar, so that if you have judges that are completely in person and you have other judges that are using remote, we're trying to figure out our scheduling so that lawyers have the ability to make all those hearings and be where they need to be, to include having Zoom rooms. And we're doing that by floors. And so there are ways that not just a qualified judiciary, but that a thoughtful and empathetic judiciary can take care of the bar. We know the concerns. We understand that not all judges are the same, but I think what we're recommending provides the necessary flexibility for the judiciary to take advantage of remote appearances and to increase access to justice when we can, but also we're aware that we need to take care of the litigants that come before us, and that we are not all the same. So I think those are things that y'all need to take, but that may not exist everywhere. But I know that a lot of other councils are aware of how it's difficult for the bar and litigants when the judiciary is not on the same page, and there are ways to address that.
Great. Thank you, Judge. Any other comments? Seeing none, we will turn to the always exciting Rule 76A. And here comes Richard Orsinger, who will trace the roots of 76A back to biblical times. He's bringing a chair.
He wants you to come up there, but.
I was gonna say, is that for the lion or what?
I'll fight right with you.
Oh, okay. We'll give this to Chip. then.
You might, that's a trigger.
Yeah, yeah, it's fine.
What do you want?
Just give it. Sure, you want.
Oh, I can sit down if I want.
Yeah.
Cool.
All right, thank you. Well, this has been a long time coming. It's been exciting. I feel a great degree of responsibility for reevaluating Rule 76A since it was adopted in 1990 for the first time. At the time it was adopted, it was standout in the whole country, and in many aspects, it's still a standout in the entire country. Chip is right. I have done a deep dive into the history, and my short article about it is appearing in the litigation magazine that Professor Lonnie Hoffman is the editor of. You can look at that when it comes out. It should be out shortly. How do we address this complex topic with so many diverse opinions? And one of the advantages we had was there are a number of people, or several people, who have been very involved in thinking about Rule 76A and what's good about it, what's bad about it, and they volunteered to help our committee, even though they weren't subcommittee, even though they weren't assigned. And so the first thing I want to do is give recognition, and my first recognition is going to be to my co-chair, Judge Ana Estevez, who, in addition to raising a child and running a district bench with civil and criminal jurisdiction, and also running the 9th administrative district for the state of Texas, and all of her other activities and committees and whatnot, has been instrumental in helping us to get to a final product to bring to this meeting today. And Ana, I want to thank you very much for your assistance. The other special mention I want to make is Steve Yalanowski, not a member of the committee, but he came to the first committee meeting with his own version of a new Rule 76A. And since that time has worked tirelessly with us to modify this rule in a way that would be presentable here at the meeting for discussion. Steve's rule was pretty radically, from my perspective, on one extreme of the perspectives about this issue. And he has nonetheless worked with us tirelessly to craft a rule that represents it, if possible, a consensus view of what the subcommittee discussions were. And so I want to thank Steve personally, and Steve will be online here, and we're going to have him participating. Now, to facilitate today's discussion, we have 3 things that you can look at. One is the committee memo. One is side-by-side comparison of the new rule and the old. And one is a red line of the literal changes that the subcommittee is proposing from the existing Rule 76A to the new Rule 76A. And I want to publicly acknowledge that Ana Estevez drafted the first draft and continued in the revisions of both the memorandum and the side-by-side comparison. So Ana, thank you so much for helping us to get that done. And then Steve has been responsible for keeping up the red line changes with all of the different discussions and emails and things that we've gotten. And Steve, thank you again for that. My proposal about the best way to address the discussion today is to use the memorandum as background material and to keep the side-by-side comparison and the red line rule out in front of you so you can just see what we're discussing when it comes to specific language. Now, the first thing to do before we dive into specifics, I think, is a few general observations. One of the deficiencies from my perspective, and perhaps others under the existing Rule 76A, is that it's possible for a party who has possession of confidential or private information of another party to file it without advance notice to the other party. And if that happens to your client, then all you can do is race to the courthouse and ask for a temporary sealing order to seal it until there can be a hearing on whether that information should remain in public view. And what has happened with that procedure is that it allows one individual litigant to make the decision whether information should be filed unsealed or not. And if the case is closely watched by the press or others, they can see that information before the judge has an opportunity to exercise his or her discretion under Rule 76A. So one of the things that we would like to do, or at least I would like to do in this proposed rule change, is to eliminate the unilateral ability of one party to file someone else's confidential information without prior judicial review. And the vehicle for that change is a notice of intent to file information under seal or not under seal. And we have a certain category for when that occurs. But the idea, I think, arose not so much in the federal district system where each local district has their own rules, but in gosh, Robert, help me here. It was the Sedona Conference proposal, which I think you sent me a copy of initially. They proposed that before certain kinds of information would be filed, you had to give notice to the other side. Now, their concern was not breach of privacy without judicial oversight. Their concern was that the parties who was required to file notice of intent was maybe didn't even want the information sealed. And so the burden was on the wrong person. Burden was maybe on someone that didn't want the sealing at all to prove that sealing would be valid. But the idea of giving advance notice makes a lot of sense from the standpoint of preserving the judge's role to decide ultimately whether the public will see certain information or not. So we've woven into this proposed rule a requirement of advance notice of intent to file confidential information. And then we're going to have to agree on what is confidential that would trigger that. The second is when Rule 76A was adopted, in the public comment, which was mostly in the form of letters, but also 2 meetings, as well as an unprecedented hearing in the Texas Supreme Court, where justices asked individual questions of witnesses who came forward to talk to the court about the adoption of Rule 76A. There was very little serious evaluation of privacy claims. It wasn't ignored because in the dissent to the adoption of Rule 76A as submitted, Justice Gonzalez and Justice Heck both noted that there was not a sufficient consideration given to privacy interests. And as we have moved along in technology since 1990, what used to maybe be called practical obscurity, that you filed a document in the courthouse and somebody from India would have to get on an airplane and fly all the way here to look at it. Well, not so anymore. To the extent that this is on the information is on the internet, it becomes available to the world. And it can be misused. It can be used for political purposes. It could be used for military purposes. There are just all kinds of possibilities that exist today that didn't exist then. I think there's also more of an awareness of the right of individuals to privacy, to have their private information remain within confined circles. And the mere fact that someone is sued in court should not mean that their tax returns or their psychological therapy records should become public to the entire world. So I think in today's environment, it makes more sense for us to engage in a balancing of the public's right to know, so to speak, against an individual or a party's right to privacy. And the right to privacy is recognized by the US Supreme Court and the Texas Supreme Court. So there is a balancing that's introduced into the rule now in this proposal that is going to weigh privacy rights against the public's right to know. Now, since Rule 76A was adopted in 1990, the Texas legislature has stepped in insofar as trade secrets are concerned, and they have given us a statutory mandate. So Rule 76A was, if you will, curtailed as it applied to the litigation of trade secrets. The question then becomes, are there other areas in which privacy rights, whether they're defined by intellectual property or whether they're defined by the 14th Amendment or Fourth Amendment or whatever. So we will see that in this proposed rule, that thought process of privacy rights, however they may be defined against the public's right to know, is now back part of the discussion. The next thing is, while Rule 76A was probably ignored largely by the agreement between the parties to enter into a confidentiality agreement during discovery, so the documents, the confidentiality order as part of the discovery process itself might define that documents can't be filed without the permission, whatever. It seems like the rule is used less than was originally envisioned because of this agreement, this complicity. And I don't mean anything negative by that, but an agreement between the parties to facilitate discovery or to facilitate settlement, that parties can agree that certain information produced in discovery will not be made public. And the rule is conceived is that every time that there was going to be any repressing of information, there would be a hearing, there would be a public notice, there would be newspapers, a judge would evaluate it. And at least in theory, if not so much in practice, it probably led to a lot of hearings that nobody was interested in. Nobody cared about the information, nobody was seeking it, nobody planned to appear, nobody did appear. So we have to sit back and look at the current Rule 76A, which appears to require a hearing before documents can be sealed. And so what you're going to find in the proposed rule, that in certain categories of information, we're going to say, if you're in this category of information and you give notice of sealing and nobody says they want a hearing, then you don't have to have a hearing. The judge can always evaluate the claim personally, anytime they want, have a hearing, whatever. But the idea that you have to have a hearing in every instance before information is sealed, we think will lead to, or has led to, a lot of phantom hearings that weren't needed, nobody wanted, and the outcome didn't make any difference. So there will be certain situations in which this proposed rule that sealing will occur unless someone requests a hearing, in which event we will have a hearing. And the notice has to go not only to the litigants, but also to the public. So the public can be advised that there are some people here that are saying this information is going to be filed in the court system, but not be made public. If you're interested, file a notice or a motion or intervene. And if they do, then there can be a hearing. But absent in these certain categories of information, absent someone saying, I want a hearing, the rule doesn't require a hearing. Now, another important feature that was left out of the original 76A, and frankly is left out of most, but not all, of the federal district court rules, is what happens if it's confidential information of a non-party, a third party, that's in the hands of a litigant, and now the opposing party has requested the production of that information. So it's not the defendant. Let's say if the plaintiff wants information from the defendant, it's not the defendant's confidential information that's at risk now. It's information the defendant has that belongs to a third party. So for example, there might have been a non-disclosure agreement in a business transaction, and there was confidentiality that was relied upon in the release of documents from, say, party X to party B. Now party B is in a lawsuit with party A, and party A wants to see all of the documents that party B has that has anything to do with anyone like X. So now all of a sudden, party X's confidential information is at risk, and they don't know. So what we have proposed in this rule is that anytime the information of a non-party that fits certain categories of protected information, anytime that that information is put at risk in the lawsuit, you have to give notice to the third party that their confidential information is at risk, so they have the opportunity to come into court and request a hearing and ask for privacy. The last, or not the last, we'll say the next change that is noteworthy, perhaps not too controversial, is the concept of re-adjudication, continuing jurisdiction. In the memo, we call it res judicata. It's not really res judicata because it's not a judgment. But the idea in the original Rule 76A was you can't come back in and relitigate sealing or unsealing if you were a party to the lawsuit or you had notice of the sealing hearing and didn't come in and participate. So this so-called res judicata concept, the idea of not relitigating, was dependent on your status as a or a third party with knowledge of the hearing. Our proposal is to shift that to a transactional res judicata concept that if the judge has adjudicated the confidentiality or the sealing or unsealing of these records, that adjudication is binding whether you were a party or not a party or knew about the hearing. And in order for you to have another court reevaluate the sealable nature of those records, you have to show a change of circumstances. You have to show that something's different, either in society or in medicine or science or whatever. But it's not just a question of that I wasn't in the courtroom when that decision was made. If the judge has considered sealing or non-sealing of a set of records on a set of facts, that's binding on everybody, and you can't relitigate that unless you can come in and show changed circumstances. And the last thing I'd like to say in my general comments is many of the things that we have talked about in this rule would apply equally to exhibits used in court. But the argument is more compelling if you use an exhibit in court than if you just file it with the district clerk. But the public policies associated with protecting information and making it, sealing it, could apply just as readily in the courtroom like it does with trade secrets. And so while it's not part of Rule 76A explicitly, because 76A is talking about documents filed with the clerk, when something's marked as an exhibit and offered in court, it's not with the clerk yet, it's with the court reporter, but still many of the public policies would apply. And the Trade Secret Act makes it clear that those protections of trade secrets have to be implemented even in the courtroom. And there is even some case law on the extent to which members of the public are entitled to see exhibits that were used in open court. So having said those comments at the general level, I want to first of all ask my co-chair, Ana Estevez, if you would like to add some general comments.
Not unless you want to just talk, you want to talk about the 5 areas?
No, I'm talking about on anything, because after this, I think we're going to get down to the specifics.
You didn't mention.
Okay, well, thank you. Appreciate that. So at this point, and we're open to comment at any stage. Let me point out that our subcommittee had very diverse perspectives on many aspects of this rule. This subcommittee product does not represent something that everyone has bought into. There are many times that there was something that I wanted to put in that it got in, and there was something that I wanted in that didn't get in. And there was something Judge Miskell suggested that got in and got mentioned, and some that didn't. And so, as I said in the memo, everyone on this subcommittee, no one is bound to this. And so if you're on the subcommittee, you don't like something, criticize it. If you're not on the subcommittee and you don't like something, criticize it. But this does not represent a consensus opinion of all of our diverse positions, because some, at least initially, were unwilling to agree that anything should be sealed. And there were others that had certain kinds of privacy rights that they felt very strongly should be protected. And so what we've attempted to do, and I compliment everyone in the process about stepping outside of their own personal views and attempting to arrive at a consensus product that we could all discuss. But unlike many subcommittees, this is not delivered to the full committee as if it's supported by the subcommittee. This is our best effort to capture the most important features to put them up for discussion. So having said that, I would suggest that we look at the side-by-side comparison, which is an easy way to see the changes, and also the red lines. And Steve Yalanowski, you're still with us, I hope, because as the author of the red line, there may be lots of times where you need to step forward. Let me just, on the red line draft, call your attention to just a few things before we get into the specific details. The first I want to call to your attention, and maybe the most important one in this whole rule, is new paragraph 3, because new paragraph 3 defines a category of information that we say would be presumptively confidential and should be filed unsealed. What goes in that category is open to debate. And I received just an email this afternoon forwarded by Steve Yalanowski from a law professor that was very much objecting to paragraph 3A3. We'll get that in just a second. But the reason we'd like to have a category of documents that are presumptively confidential is so we can say If these records fit within this category, then they're presumed to be subject to sealing unless somebody with notice of the intent to file sealed documents says, I have a stake in this. I have an opinion in this. I want a judge to decide this. Let's have a hearing. The idea then is that once we agree on what this paragraph 3 information is that would be presumptively sealed unless someone proves it shouldn't be, then we don't have to have a hearing for that unless someone requests it. That's the fundamental idea. Now, inside paragraph 3 is what I was talking about, these privacy rights. And these are the ones that we listed. And some people didn't like any of them, and some people liked 3 or 4 of them, but not all of them. So the first category is trade secrets or other proprietary information of a party or non-party. That ought to be the easiest one here for us to agree on, because we got a legislative enactment that tells us that we have to have certain protections for trade secrets. So I would argue the legislature has already told us that that is a category of privacy rights that the presumption of openness shouldn't apply to. The second category is information that is confidential under a constitution, statute, or rule. That's a broad category, and we've had some criticism of what constitutes something that's confidential under a constitution. Statutes are a little bit more specific. Rules, like a rule of evidence, like attorney-client privilege, doctor-patient privilege, mental health privilege, that's a rule that says that that information is confidential. We already have a public policy saying that other people can't see it. Not only other strangers in society, but other litigants in the same lawsuit with you. So we already have a public policy that's been stated in the rules regarding confidential information. So that would fit under category 2. What would fit under the constitutional right of privacy? That's broader and vaguer, but we do know we do have some case law about certain kinds of information that is within the zone of privacy, constitutional zone of privacy inside the family. Category 3, probably the most controversial one, information subject to confidentiality agreement or protective order. Well, that's probably one of the weaknesses of the Rule 76A right now, is that a plaintiff and a defendant can enter into a confidentiality agreement about documents produced in discovery. Usually it's in the form of an order that gets submitted to the court as an agreed order and gets signed. And as a practical matter, in most instances, you're going to find that it's effectively a sealing order that never was treated as a sealing order and never was published as a sealing order. So an argument can be made that category 3 is really one of the problems with 76A, and perhaps it should be eliminated. But the trade-off against that, which was in the original debate as well as in case law after the fact, is that it really facilitates discovery. If a plaintiff and a defendant can agree that information that's produced is not going to be filed in court. And then they don't have to fight at the discovery stage about not revealing the information out of fear that it might be filed later and become public. So I think a lot of people that testified and wrote letters in the initial 1990 process, as well as communication since that time, is there is a public policy in plaintiffs and defendants agreeing that if you show this to me, I promise you I won't file it with a record without advance notice to you. And so then maybe a lot of cases that discovery moves through with fewer hearings, the courts are not burdened, it's less expensive for the litigants. But you know, the party that received it always has the right to say, I'm going to give you notice, I'm going to file a motion with the court, I'm going to ask the court to unseal it. So there is, I think, a way to protect against confidentiality agreements and protective orders gutting the rule. Category 4 is information subject to a pre-suit non-disclosure agreement with the non-party. We're talking here about in a business transaction, party X reveals confidential financial information to party B under a non-disclosure agreement, and they financial information, legal information, who knows? And then party B gets in a lawsuit with party A, and the discovery request would include party X's records in party B's possession. So the idea is that if it's subject to a bona fide non-disclosure agreement with a non-party that's historical, not related to the lawsuit, but pre-existed, there should be a presumption that they have a right to privacy with that, and it should only be revealed if a judge determines that it should be revealed. And the last category is an order changing the name of a person to protect that person from a well-founded fear of violence, which is statutorily driven, but also in the public policy and the family codes and all of the stuff we're doing about family violence. So obviously, I mean, the most obvious one is that if someone has been a victim of family violence or violence from a connected party, we don't want their address and telephone number and email address and job descriptions made public because they could be easily misused. So that is a category in which we felt like it would be safe, it would be appropriate. In fact, it's already been publicly determined that our public policy is to protect those kinds of potential victims from having their information revealed. Now, in the original 76A, there is no category that's presumed to be private. It's just all presumed to be public. And the party that comes in has to show all the extraordinary things that the current rule current rule contains. So this is a big sea change here, but in my view, it's an appropriate sea change because there are areas in which we can agree our government system, our society recognizes privacy rights as being more important than the public's right to know. And just remember, I mean, the original debates, the plaintiff's lawyers said, you know, I have to go into court. My client has to produce all of their medical records, all their psychological records and everything else. That's true. And they have to make an election about that. But does it have to be an election to make it public or just make it available to the defendant? What about the defendant who gets sued and didn't want to come into court at all, but now there's an allegation that their physical or mental health contributed to harm to the plaintiff? They didn't invoke the court system. They're just defending themselves. This is information that's confidential. So the question becomes, to what extent is it necessary for the plaintiff in order to pursue their suit? But there's a separate question, which is to what extent is it necessary for the public to find out about this in order to achieve due process between the two parties? One last thing I want to say on paragraph 3A is that in the event in the future, there's a discussion about it. There are two kinds of presumptions that Texas law recognizes. One is a presumption that vanishes in the face of contrary evidence, and the other is a presumption that lasts all the way through to the final fact find. And if you dig into the evidence law, the presumption that vanishes in the face of contrary evidence is called assigns the burden of production of evidence, and is called a Thayer presumption after Professor Thayer. Professor Morgan was of a contrary view that the presumption is a burden of proof in the final finding, and that doesn't disappear even in the face of contrary evidence. So I think for some future Court of Appeals case, they're going to want to know is, well, if we have this presumption in here, is it a Thayer presumption or is it a Morgan presumption? And it's my suggestion that it's a Morgan presumption. We want the presumption of privacy to apply until a judge decides that the evidence supports overturning the presumption. We don't want it to just vanish because there's contrary evidence. So we're skipping over the whole thorny question, one of the biggest fights in the original 76A process, which was unfiled discovery. And we're not attempting to change that. Although if some of these principles are agreeable to your perceptions of what we should do, maybe we could look at that. But it's been my observation that there hasn't been a terrible lot of litigation about unfiled discovery. It was something that I think terrified some of the people that were involved in the process. And Tom, you probably have a better sense than I do whether anybody's ever tried to look into your files to get information from an old case. Does that ever happen to you? Has it happened recently?
No.
Okay. Well, it's a matter of concern, and we didn't do anything about that. That doesn't mean it shouldn't be considered, but it was a hugely controversial at the time the rule was originally adopted. So then the next point I'd like to move on to is paragraph 3B. And this is an important thing. Once we decide that there's a category of private documents, private information, then under B, it will automatically be sealed on request without a hearing unless somebody requests a hearing. And to be sure that everyone who is a stakeholder knows that notice has to be given to the adverse parties, to the third parties whose information is involved, and to the public that a request has been made to seal this information. And if it fits in the category of what we would call presumptively confidential information, no hearing is required unless someone asks for one. And that's in order to avoid these phantom hearings that nobody really wants, that nobody really cares about, but the judge has to conduct anyway, because the rule is written in such a way that you have to have a hearing before you can seal. So if we have a good definition of where the information that's protected by presumption of privacy, then we have a workable B, that unless somebody within 14 days of notice files a request for a hearing, it's going to automatically be sealed, subject always to someone filing a motion to unseal. The next point is paragraph 4 is the notice of intent to file confidential information unsealed. Once we have a definition of confidential information, paragraph 3 information, and a party wants to put it in the public record, they have to give notice before they file that they're going to do that. And when that notice is given, then the other parties, whoever's has their information at stake, has the opportunity to come into court and request that the court order that it's be sealed. Paragraph 6 is the notice to third parties. I talked to you about the people who are not litigants, but whose confidential information is about to be filed unsealed. Paragraph 9 on order beefs up the specificity requirement that exists under current Rule 76A, so that the court is more literally describing what information is being sealed. And there's an option of redacting paragraph numbers or sentences or social security numbers or whatever, but there's more of a requirement on the trial court under this proposed rule to be very specific about what part of a document you're going to seal, because maybe one paragraph should be sealed and the rest not, but the inclination now is to seal the whole document. So we're trying to get the judges to be more specific about that. On paragraph 10, I already mentioned this idea of continuing jurisdiction. Who should be required to prove a change in circumstances when they come in later on? And our idea is that it's transactional rather than party status. And then 13, we included a sanctions rule, not a new sanctions rule, but a cross-reference to existing sanctions, Rule 13 or chapters 9 or 10 of the Civil Practice and Remedies Code, because it is clear if we create this category of private information that can be manipulated or gamed by litigants or by lawyers. And so we want lawyers to be honest with the court and not misrepresent that certain documents fit the category of privacy when it doesn't. And if somebody gets caught doing that, they should be punished, not just out of a sense of vengeance, but as a deterrent to people misrepresenting to the court that we have Section 3 information here, paragraph 3 information don't. So the mention of the sanction is not to create a new sanction rule, but just to remind the lawyers and the judges that if this rule is misused so that it creates an injustice or sets up an injustice, and the court is satisfied that Rule 13 was violated or Chapter 9 or 10, then the court can consider sanctions. So that's my high-level discussion of the specific paragraphs. Anna, do you have anything that you want to say?
No,
Come up here, please.
I noticed a typo, so I just want to make it clear that where we had under paragraph,
What document are you in?
I'm in the comparative chart,
Okay.
but I think it's when we renumbered the paragraphs, we referenced paragraph 5A under paragraph 3B, where it states after 14 days from the date of the notice required under paragraph 5A, if you'll just take off that A, we had a 5A and a 5B, and we ended up renumbering all our paragraphs. So that'll make more sense.
It's a typo. Hey, we're including already a two paragraph.
Okay, fix that too. Well, thank you. That's,
All right.
yeah, I'll let you go through the changes then.
Okay, so Steve Yalanowski, are you on the line with us?
Yes, can you hear me?
Yes, I can hear you quite clearly. Good. So Steve, I think what I'd like to do is to go through this proposed rule change with a highlight on the reds. And I'm happy to do it, but I would also be happy for you to do it because you are actually the author of this red line and you know some of the mental processes that went into what was done. Are you in a position where you think you could start us through the rule on a section? Yes.
Before you do that, we're going to take our afternoon break.
You have an afternoon break.
We'll be back in 15 minutes.
I'll be back in 15 minutes. So that's going to be 3:31.
Sure.
Okay.
3:31.
Thank you. So Steve?
Yes.
Stephen?
Yes.
Okay, do you want to take us through on a red line by red line basis?
I couldn't hear Chip. Did he say we're going to take a break now?
Yes, right now.
We're going to take a break now?
Yes, we're going to take a 15-minute break right now.